The modern era begins. International Shoe Company v. Washington. During the decades following Pennoyer, many judges began to think about the meaning and sources of law in new ways. For example, judges were increasingly skeptical that the law contained a body of immutable right, scientifically derived natural principles that judges could objectively determine without reference to the real world implications of those principles. Rather, many judges began to believe that at least some legal doctrines are indeterminable and are necessarily interpreted and developed in light of social, political, economic realities. Judges who adopted the legal realist view of the law found it easier to move away from formalistic doctrines such as the rigid principle theory and Pennoyer that did not seem to correspond to the realities of a modern mobile world. Legal realism arguably played at least some role in the evolution of personal jurisdiction doctrine. Reading International Shoe Company v. Washington. This case illustrates why personal jurisdiction doctrine has become so problematic in light of modern realities. The state of Washington had insisted that International Shoe, a company that was incorporated in Delaware, had its headquarters in Missouri, made contributions to the state of Washington's unemployment fund. International Shoe had no offices or permanent employees in Washington, so it was a stretch to say that the company was present there. The state of Washington had insisted that International Shoe, a company that was incorporated in Delaware and had its headquarters in Missouri, made contributions to the state of Washington's unemployment fund. International Shoe had no offices or permanent employees in Washington, so it's a stretch to say that the company was present there, even using the expansive present concept, the expansive presence concept that courts had developed. At the same time, the court clearly considered it reasonable to expect International Shoe to defend certain kinds of claims in Washington. Consider the following questions when reading the case. Does the court extend the definition of presence, or does it choose a new path? If the latter, what is the court's approach to determining when in personal jurisdiction is constitutionally permissible? Pay close attention to which of the defendants and state contracts are deemed to be important and how different types of contracts lead to different jurisdictional consequences. In particular, what are the jurisdictional consequences when a defendant has no contacts in the forum, single or limited contacts, or C, extensive contacts? International Shoe Company v. Washington. Mr. Chief Justice Stone delivered the opinion to the court. The questions for decision are: one, whether within the limitations of due process clause of the 14th Amendment, an appellant, a Delaware corporation, has by its activities in the state of Washington rendered itself amenable to proceedings in the courts of the state to recover unpaid contributions to the state unemployment compensation fund exacted by state statutes under the Washington Unemployment Compensation Act. Two, whether the state can exact those contributions consistently with the due process clause of the 14th Amendment. The statutes in question set up a comprehensive scheme of unemployment compensation, the costs of which are defrayed by contributions required to be made by employers to a state unemployment compensation fund. The contributions are specified percentages of the wages payable annually by each employer for his employees' services to the state. The assessment and collection of the contributions in the fund are administered by respondents. Section 14C of the Act authorizes the responding commissioner to issue an order and notice of assessment of delinquent contributions upon prescribed personal service of the notice of the employer is found within the state, or if not so found, by mailing the notice of the employer by registered mail at his last known address. In the case, notice of assessment for the years of question was personally served upon a sales solicitor employed by appellant in the state of Washington. Had a copy of the notice was mailed by registered mail to appellant to the address in St. Louis, Missouri. Appellant appeared specifically before the Office of Unemployment and moved to set aside the order and notice of assessment on the ground that the service upon the appellant salesman was not proper service upon appellant. The appellant was not a corporation of the state of Washington and was not doing business within the state, that it had no agent within the state upon whom service could be made, and the appellant is not an employer and does not furnish employment within the meaning of the statute. The motion was heard on evidence and a stipulation of facts by the appeal tribunal, which denied the motion and ruled the respondent commissioner was entitled to recover the unpaid contribution. The action was affirmed by the commissioner, both the Superior Court and the Supreme Court of Washington affirmed. Appellant in each of these courts assailed the statute as applied as a violation of the due process clause of the 14th Amendment and as imposing a constitutionally prohibited burden on interstate commerce. The cause comes here on appeal, appellant assigning as error that the challenge statutes as applied infringe the due process clause of the 14th Amendment and Commerce Clause, 166, page 166. The facts as found in the appeal tribunal and accepted by the state superior court and Supreme Court are not in dispute. Appellant is a Delaware corporation having its principal place of business in St. Louis, Missouri, and is engaged in the manufacture and sale of shoes and other footwear. It maintains place of business in several states other than Washington, at which its manufacturing is carried on and from which its merchandise is distributed interstate through several sales units or branches located outside the state of Washington. Appellant has no office in Washington and makes no contracts either for sale or purchase of merchandise. It maintains no stock of merchandise in that state and makes there no deliveries of goods in interstate commerce. During the years from 1937 to 1940, without question, appellant employed 11 to 13 salesmen under direct supervision and control of sales managers located in St. Louis. These salesmen resided in Washington. Their principal activities were confined to the state, and they were compensated for their commissions based upon the amount of sales. The commission for each year totaled more than $31,000. Appellant supplies the salesman with this line of samples, each consisting of one shoe of a pair, which they display to prospective purchasers. On occasion, they rent permanent sample rooms for exhibiting samples in business buildings or rent rooms in hotels or business buildings temporarily for that purpose. The cost of such rentals is reimbursed by appellant. The authority of the salesman is limited to exhibiting their samples and soliciting orders for prospective buyers at prices and other terms fixed by appellant. The salesman transmit the order to appellant's office in St. Louis for acceptance or rejection, and when accepted, the merchandise fulfilling the orders is shipped free on board, meaning that the seller has completed its obligation upon delivery to the carrier of the goods from points outside of Washington to the purchaser within the state. All the merchandise shipped into Washington is invoiced at the place of shipment, from which no collections are made. No salesman has authority to enter into contracts or make collections. The Supreme Court of Washington was in the opinion that the regular and systematic solicitation of orders in the state by appellant salesmen resulting in a continuous flow of appellant's product into the state was sufficient to constitute doing business in the state so as to make the appellant amenable to suit in its courts. But it was also of the opinion that there were sufficient additional activities shown to bring the case within the rule frequently stated that solicitation within the state by the agents of the foreign corporation, plus some additional activities that are sufficient to render the corporation amenable to suit brought in the courts of the state to enforce an obligation arising out of the activities there. The court found such additional activities in the salesman's display of samples, sometimes in permanent display rooms, and the salesman resident within the state continue over a period of years, all resulting in a substantial volume of merchandise regularly shipped by appellant to purchasers within the state. Appellant insists that its activities within the state were not sufficient to manifest its presence there, and that in absence of the state courts, a subject that in absence, the state courts were without jurisdiction, that consequently, it was a denial of due process for the state to subject appellant to suit. It refers to those cases to which it is said that the mere solicitation of orders for the purchase of goods within the state to be accepted without the state and filed by shipment of the purchased good interstate does not render a corporation seller amenable to sue within the state. And appellant further argues that since it was not present within the state, it is denial of due process to subject to its taxation or other money extraction. It thus denies the power of the state to lay tax or to subject appellant to a suit for its collection. Historically, jurisdiction of courts to render judgment in personam was grounded on their de facto power over the defendant's person. Hence, his presence within the territorial jurisdiction of the court was prerequisite to the rendition of a judgment personally binding on him. Penoyer v. Neff, 95 U.S. 714, 733, 1877. But now that the capias of Adam respondum, the rest of the civil defendant has given way to personal service of summons or other form of service, due process requires only that in order to subject a defendant to judgment in personam, if he is not present within the territory of the forum, he have a certain minimum contact with it, such that a maintenance of the suit does not offend traditional notions of fair play and substantial justice. Milliken v. Meyer, 311 U.S. 457, 463, 1940. See also Hess v. Pawlowski, 274 U.S. 352, 1927. Since the corporate personality is a fiction, although a fiction intended to be acted upon as though it were fact, it is clear that unlike an individual, its presence without as well as within the state of its origin can be manifested only by activities carried on in its behalf by those who are authorized to act for it. To say that the corporation is so far present there as to satisfy due process requires, for purpose of taxation or the maintenance of suit against it in the courts of the state, is to beg the question to be decided, for the terms present or presence are used merely to symbolize those activities of the corporation's agent within the state, which courts will deem to be sufficient to satisfy the demands of due process. Those demands may be met by such contacts of the corporation with the state of the forum and make it reasonable in the context of our federal system of government to require the corporation to defend the particular suit which is brought there. An estimate of the inconveniences which would result to the corporation from a trial away from home or principal place of business is relevant in this connection. Presence in the state in this sense has never been doubted when the activities of the corporation there have not only been continuous and systematic, but also gave rise to the liability sued on, even though no consent to be sued or authorization to an agent to accept service of process has been given. Conversely, it has been generally recognized that the casual presence of the corporate agent or even his conduct of single or isolated items of activities in the state and the corporation's behalf are not enough to subject it to suit on causes of action unconnected with activities there. To require the corporation in such circumstances to defend the suit away from its home or other jurisdiction where it carries on more substantial activities has been thought to lay too great and unreasonable a burden on the corporation to comport with due process.